There we go. Hi, everybody. Just going to wait a few seconds, make sure everybody is here with us. Looks like everybody is there. We are going to get started. Welcome to our August 2021 General Membership Meeting and CLE Luncheon. For those of you that I haven't met before or don't know, my name's Ariane. I am the president this year at Kappa. Happy to see everybody here today. We are very fortunate to have Emily Morris of the Morris Law Firm with us today, and we will introduce her shortly and start with our presentation shortly. As most of you know, we initially planned this meeting to be a hybrid presentation, both in person and via Zoom. Due to the ever-changing nature of our current world, we chose to hold this month's CLE strictly via Zoom. We appreciate your understanding and flexibility as we navigate events this year. We will continue to make decisions monthly based on updated information as it's available and based on concerns expressed by our members and our presenters. A few housekeeping reminders before we get started. Please be sure and mute yourself throughout the presentation. Please pose questions via the chat. We will take questions throughout the presentation. We have a volunteer monitoring these for the speaker, and we will get to all of them. If there are technical issues with the Zoom link, we will restart the presentation immediately. CLE certificates will be sent out at the end of the presentation via email to those that are registered and that are in attendance. So please list your Zoom name as the name you used to register in order to be counted as present and receive your certificates of attendance. Speaker materials were sent out this morning, but also will be available hopefully by this afternoon on the speaker zone. And we will have some door prizes and announcements at the end of the CLE. So please stick around. You must be present to win. Our spotlight vendor this month is Kim Tyndall and Associates and Jennifer Chambliss. Did I say your name right, Jennifer?
It's Chambliss.
Chambliss, sorry. So Jennifer Chambliss, okay. Thanks. She'll speak briefly before we get started. And it's
okay. Well, thanks for having us today to be your spotlight vendor. I hope that everyone can hear me okay. I'm at my house and I live way out in the country, and sometimes my signal is not that good, so I do apologize. But anyway, I did want to speak for KTA. You know, we're now a Magna Legal Services company. We've been around for, a long time. I know Kim's been around since the 80s, I believe, as far as having a business of her own. She recently sold out in April to Magna, and we are really fortunate. We've added so many things to the suite of services that we're doing. You know, we've always led with court reporting, and we're still very good at it, and we're still continuing to do that. But we also now are leading with records. We are now offering nurse review, and we're also offering data mining, which is something we did not offer prior to Magna getting us. And we also are really involved in the trial world these days. We offer online focus groups, which is, you know, something that a lot of you or your attorneys may be interested in right now, you know, since COVID has gotten bad again, and these attorneys are not wanting to do the in-person mock trials. We're doing witness prep, jury selection, trial graphics, and accident reconstruction. Plus, we also offer like 20 CLEs. So if you're interested in CLE for yourself, CLE for your entire firm or your attorney or whatever, just reach out to me and let me know, and we can get that set up. They're free, and usually I'll have lunch sent to your firm while you're doing your CLE. So I will put my name in the chat bar and my email address in case you're interested. And I really do appreciate y'all allowing us to be here today to do this. Thank you.
Awesome. Thanks for being here. And at the end of our CLE, Jennifer has very generously donated 2 $25 gift cards that will be drawn at the end of our presentation. And with all of that said, I'm going to let Amber Haney introduce Emily Morris from the Morris Law Firm for today's presentation.
Hi, this is Amber, and we're very thankful for Emily for presenting for us today. Emily is a Texas business attorney with financial certifications and marketing degree. She provides full picture legal solutions to companies and individuals in the areas of business law and real estate. She especially enjoys partnering alongside small business owners to attain proactive and creative solutions that fit their visions for company growth. She received her undergraduate in business administration marketing at Louisiana State University and focused on corporate and international law while completing her Juris Doctorate at Tulane University. In addition to law practice, she enjoys hiking Central Texas trails with her hubby and singing with Chorus Austin. She's been named an Austin Top Attorney by Austin Monthly, and this year she's one of the 2021 Texas Rising Stars, Thomson Reuters Super Lawyers. So thank you very much, Emily, and we will let you take it from here.
All right, thank you so much for having me. I'm going to share my slides, so let me make sure I'm doing this right. Okay, I'm gonna get my PowerPoint set up here. Okay. How does that look to you all? Does that look good? Okay, perfect. All right, so as Amber was saying, I work with a lot of small business owners, and so that can run the gamut from setting up companies to drafting contracts, and also advising generally on IP. I would definitely say I'm a generalist in this area. The primary things that I work with are trademark filings, registrations, and contracts, so like licensing and that sort of thing. So I'm going to keep it really high level. There's 5 main categories that I'll go over, and so feel free to drop questions in the chat, and I'll try to take a pause between the main categories and answer any of those. And of course, I'll be happy to save some time at the end as well. All right. So legal disclaimer, I'm not giving you legal advice. I'm just giving an overview of different generalities that may or may not apply to a particular situation, but you know that. And I would love to be your friend. Let's see. Okay, so there's 4 main categories of IP, but I add in contracts as a 5th because that kind of modifies and runs the gamut for all of the other 4, or applies to all the other 4. The first one we'll go over is copywriting, but I'll just give some examples of what each of these are in case you're not already familiar. So a copyright is the original content that somebody comes up with. So if they write a song, it's the song itself. Trademarks are, or if the business owns like if you're a publishing company, it's the magazines that they put out, it's the books that they put out. Trademarks are the identifiers for who you're doing business with. So you see McDonald's Golden Arches, you're getting a McDonald's hamburger. You see an Apple logo on your computer, you're buying a Macintosh. Patents are actual like processes and procedures and designs. So the machinery for a tractor. That's an easy example of a patent. Trade secrets are different. They are not publicly filed like everything else. They are in fact secret. It's confidential information that gives a business a competitive edge over the guy down the street. And so I'll get into that a little bit more later. And contracts, as I mentioned, kind of are all encompassing, but extremely important. So it Contracts are how businesses will protect their IP through confidentiality clauses. You can assign your rights to another entity or to somebody else, and you can also license your IP for various reasons. And I can get to some of that a little bit later. So I have just a generic example here of what each of these are. So copyright would be the content on Torchy's website. Trademark would be their name, Torchy's Tacos, also their logo, the little double guy with the horns. A patent would be if they owned any special kitchen equipment that they use to make the product. Trade secrets would be the actual recipes that are internal to them. And any contracts for IP would probably, I don't work for Torchy, so I don't know, but I'm guessing they probably have employment agreements with confidentiality language. And if they ever had franchises, they could assign their use of their IP to the different franchise owners. So we'll go into copyrights a little bit more in depth now. So these protect original works of authorship, literary, musical, dramatic, choreography, audiovisual, sound recordings, and architectural. So pretty broad categories there. If any of you work with firms that represent small businesses, website content is pretty much going to apply to anybody. So any blog posts that your clients put up, pictures, any written content really is copyrightable. Books, pictures, like I mentioned earlier. It is protected by Article 1, Section 8 of the Constitution. Feel free to read that if you feel like it. And then that's codified in the US Code, see, Title 17. So the Section 102 subject matter in general kind of is a more in-depth description of what I was just talking about, but that's our legal basis for copyright law. So it's all federal. Any enforcement of copyright disputes would have to be filed in federal court. Let's see, the purpose of registering a copyright. So copyrights are different from other types of IP in that you inherently own the copyright already just by writing the song, just by writing the book. That is your IP that you already own. You would want to register it if you were ever inclined to want to protect your rights in federal court. You would want to use the little C symbol with the circle to give other people notice of ownership, saying, I told them that this is my my song, my website content, that sort of thing. So that is very effective on its own, but you want to take that step further of registration in order to actually have some enforcement power behind that. Registering copyrights also gives contact information for the owners. So if somebody's interested in licensing a song to do like a cover or something, it would tell that person who to get in touch with to initiate that conversation. One note for the modern internet era is DMC takedown notices, and I don't know if y'all have come across that, but that is extremely common these days. It's I believe it was a statute excuse me, codified back under Bill Clinton. So it's been in effect for a while, but it's come into play over the last few years more frequently. Digital Millennium Copyright Act. So that is the process for people to give notice if they think that their content has been plagiarized on the internet. The person who thinks that they've been copied can give official notice to the website owner, say, hey, that's my content, please take it down. And then the burden's on the website owner to then look into it, see if it's legitimate, and if it is legitimate, they have to take it down. And if not, they can provide a counter notice saying, no, this is, this is fine as it is. Sorry, you're mistaken, and kind of go from there. But that's something that you'll see, especially like with photographers. Their photos are taken all the time, and it's so easy to copy paste. So something to keep in mind. How do you apply for registration? So the U.S. Copyright Office handles all of it. I've got the link here to some of the forms, but they're paper forms. So this one's a little bit old school. Trademarking, it's all online, but copywriting, you'd fill out the form, mail it in, and just kind of wait for the registration process to proceed that way. Copyrights last a long time. The idea being that it can't be forever. Like ultimately things that end up in the public domain. And so the owners' families can benefit for 70 years beyond their passing. But then at some point it just becomes some, I'll use, let's see, old hymns, for example. So hymns from like the early 1920s would be in the public domain now. So that means anybody can use it freely however they want without having to get a license or certain special permission to use it. I already mentioned legal disputes would be in federal court, and that's the basics of copywriting. So I will take a minute and see if are there any questions. And if not, I will go on to trademarks.
I don't see any questions in the chat right now.
Okay. All right, so we'll just keep on moving. Trademarks, sorry, I got ahead of myself there. So like I was saying earlier, trademarks identify the seller of goods or services. So the name Torchy's Tacos tells you that you're getting your tacos from Torchy's. It protects consumers from confusion, and it also protects the business owner's IP. So the primary function of a trademark is so if I'm going shopping and I'm looking for New York and Company clothes, I don't get distracted and end up at NYC clothes like right next door and think I'm shopping at the same place. Not that I would do that because I'm a fan of New York and Company too much, but it's to protect from consumer confusion. And also as a business owner, they invest in their brand, and so they need to be able to protect that. So that's what trademarks allow us to do. It's a little bit different from copywriting in that you do have to register it essentially to even have a presumption of ownership. There are common law rights that I won't get into in too much detail today because I want to keep this fairly high level, but trademarks last 10 years. You need to apply for it as soon as feasible. And then in case of a conflicting mark, the first person to file for their registration gets the benefit of the doubt. So it's really important to apply for those as soon as possible. Types of trademarks, there are many. There's word marks, which would be Torchy's Tacos. There's logos, design marks, which would be, like I said, the little double guy. Slogans, damn good tacos. Product names, Diablo sauce. A service mark would be if I were to register something for providing legal services. If I was to be the damn good lawyer, that would be a service mark. And trade dress is packaging. So I don't know if y'all remember Maybelline mascara, the pink tube and the green cap, but that would be trade dress. So if you're looking for that specific mascara, you see those colors and that design, you think Maybelline. Federal trademarks are based on the Lanham Act, which is also in the US Code, Chapter 22, and it creates a national system of trademark registration. There are also statewide trademarks. For Texas, you can apply through the Secretary of State. State law would govern that. And then there are international trademarks as well through a process called the Madrid Protocol. I will explain a little bit about the difference between those three things. So federal trademark, it gives you protection across the United States. So that's the gold standard. That's what you want. If you're not able to get a federal trademark for some reason, or you don't anticipate doing business outside of the state you're in, like outside of the state of Texas, but you still want some protection against in-state competition, you can apply through the Secretary of State. And then the international registration, there is no international governing body. What happens is there's all these different countries who have signed the Madrid Treaty. And so if you're doing business in another country, I'll give England as an example. If I want to open up a shop in England and I'm already have a registered trademark in the United States, then I apply through, it's called WIPO, W-I-P-O. But I apply through this online software to register my US trademark in England. And so it does, since it's already approved in the US, I can have it protection in England. But so you can't get a worldwide trademark, but anywhere that you're set up to do business, as long as they are, the country is part of this treaty, you can register your trademark there too. Trademarks must be distinctive. So Apple is an easy example of that. Distinctive meaning it's something weird and out there that is not just super descriptive or generic, as I have here, bad of the brand. So Apple is a good example of being distinctive because there's nothing resembling an apple about my iPhone or my computer besides the logo itself. The trademark office does not like descriptive or generic marks because that is, they don't want people to be able to take something off the market in order that would otherwise tell a consumer what they're offering. For example, let me think. So if I were a produce store in Austin and I wanted to call myself Austin Produce, I can't register that because it's just telling people what I'm selling, and it wouldn't be fair to other like say Austin Farmers Market or something like that. It wouldn't be fair to take that possibility of naming off the table of any possibilities for other companies. So distinctive, good; descriptive, generic, bad. And that can apply to primarily words. Visuals are a lot easier to register because they're typically original designs, and it's just an easier way to go. But if you can register a word mark, that's I'll go back to the gold standard again. That's the best that you can do, because that gives you the broadest protection against any other competition who might be infringing on those rights. Amber asked who decides whether the trademark is generic. Okay, so I'm getting a little bit ahead of myself here, but the U.S. Patent and Trademark Office is the governing body for any patent or trademark filing. So U.S. Copyright Office is its own thing. Patents and trademarks are together. And I'll get to that registration process in just a moment, but they get to decide everything. unless and until you disagree with them, and then you would take it to a federal court. I've already talked about state and federal issues. You would want to conduct a trademark search before you file. So it's not a cheap process. And so basically your firm could be paid a bunch of money to file an application just to find out that there's another registration that's very similar and have it rejected. So you want to have as much information going into it as possible. So I will see if I can shift my view to show you what that might look like. Let's see. Give me just a moment. Okay, here we go. Oh. Okay. Sorry. All right, so I'm at the Trademark Office's website, tmsearch.uspto.gov. I'm going to do a basic word mark search. This is the first thing I will do for, sorry, it's saying it expired. I had this set up before we started today. This is the first thing I will do for any trademark issue. So let's say I want to be world's best lawyer. I'll just type that in here. Submit query, see what comes up. Oh, somebody's got it already. So that tells me, oh, but if I scroll down to the bottom, I see that it is a dead, a dead trademark. So that means it's not a conflict. It was canceled for whatever reason. And then I can click on this TSDR button, and that will tell me everything I need to know about this registered trademark. This, actually it's not registered, but that'll tell me everything I need to know about this application, that it no longer exists. So I can see the name, I can see when they applied for it. Looks like it did register back in 1994, and then they canceled it in 2001 because they didn't file upkeeping documents. So I mentioned that trademarks last for 10 years. So you can renew after for another 10 years automatically, but you do have to file paperwork showing that the trademark is still in use, essentially. I can click here under mark information, goods and services. So goods and services is important. I'll show you that in the mark search, but legal consultation is what they're doing. The goods and services is just a description of what the company does. So lawyer search services, legal consultations, and they have different international classes. International classes meaning, so I mentioned earlier that you can register your, if you have a US trademark, you can register it in England if you're doing business there. So all the countries that are part of the Madrid Treaty, they all share the same classes of goods and services. So just to keep things simple. And then I can see the attorney who filed the application, the owner's name and contact information. And then here under prosecution history is where I can see everything that's ever happened on this application. I can see when it was filed, if there was any back and forth between the examining attorney and the applicant. So once you do file an application, it says here assigned to examiner. An examining attorney employed by the trademark office will be your primary point of contact, and they'll be, making a lot of these. They'll be the ones making decisions on any arguments and whether or not to approve the application for registration. And then ultimately, if you go back and forth with them and you don't agree, and it's worth it to your client to continue the fight, then that can be appealed, and you can resolve those things in federal court. Okay, so I will now go to markify.com. So the first thing I do is go to that trademark search, just do the generic search on the trademark database, see if anything's there. And then beyond that, then I want to order a comprehensive search. So this is something that you all might do to support your attorney's practice. That you'll want to order a search. So this is, I have a subscription to Markify. So I'm gonna do a sample search from their website. Let's see. Well, now it's not letting me log in. If it lets me, then I will. If not, I'll just give you a description of the process. Let's see. Sorry about that. Okay. Give me 2 seconds and it should work. And if not, I will leave it alone. Okay. Order a comprehensive search. Okay, here we go. So it's pretty easy. You would want to, if I'm doing World's Best Lawyer, that's what we type in here. Select databases. So I tell the search what I want to use. Custom default is typically going to, we're going to look at any federal trademarks. This will also pull results from any secretaries of state that are just statewide trademarks. It'll search the entire web for the different domain names, different business names, and then also social media image searches. It's a lot of information. And I just do the comprehensive search. You can also pay for somebody else to review it. But what I typically do is I'll order the search, review it myself, and then go over it with my client. Select classes. So this is what I was talking about with the international classes. If I'm doing World's Best Lawyer, I go to services. This is the service section down here. And it'll be class 45, legal, personal, and security services. If I am Target and I'm selling everything that Target sells, I'll be products, and I'll be selecting all of the different options there. So I'd be selecting furniture, toys and sporting goods, that sort of thing. See. And once I've got those things in, I put it in the cart and I order it, and it comes to my inbox in a few hours. So it's really easy. Highly recommend doing it. And then that'll help your clients know if they should be applying for something or not. So we'll go back to the PowerPoint and move on to the next thing. Okay, do international trademarks also need to be registered locally? Yes. Yes, you would start, if it's an American company, you would start by registering it in the United States. And then if you open a branch overseas, then you would register it in that country. But it would really just be like taking the US trademark and registering it there, but it's not like applying for a whole new trademark. Or if you're an Australian company and you want to do business in the United States, you initially apply for your trademark in Australia. And then whenever you open your US branch here, then through the Madrid Protocol, it's like a duplicate. You register that same Australian trademark in the United States. Any other questions on trademarks before I move on?
I don't see any other questions just yet. So can I ask quickly, is it, are there issues like if you, let's say you're a US company and then you go to Australia or vice versa, is it like a foreign, like, is it recognized in a different country if it's already in existence, like let's say in your home country, or is it, do you run up against issues with, you know, having multiple people using the sort of same word or same image or same trademark, if it's like for lack of a better word, a foreign registered?
Yeah, so provided that the country is part of the Madrid Treaty, as you know, most like Western countries are, then you get the benefit of the doubt. You don't have to go through the same stringent application process that you do at the outset when you're first applying for it.
Okay,
You just get to say, hey, I'm doing business here.
thank you.
Okay, and that's all. Everything with trademarks is done electronically. They make it super convenient. Okay. Patents. I am not a patent lawyer. Don't even want to give that impression. So I'll just give very basic high level info on this. Patents protect methods, processes, machines, composition, what we all like to call inventions. So the machinery in your Toyota Corolla could be most likely is patented. The hardware in my computer is patented. It's anything novel and non-obvious and original. There are very stringent requirements in order to register a patent. It's also governed by the Constitution, Article 1, Section 8, and codified in Title 35 of the US Code, if you're ever really bored and want some good reading there. Also apply through the US Patent and Trademark Office, but it's totally different process. You would typically have a licensed patent attorney prosecuting the patent. So there's a separate patent bar that that attorneys take to become admitted before the patent office, and they typically have to have like a science or technology background in order to do that, which I did not, as you heard. My background's in marketing. So, patents have a 20-year term, which can also be renewed so long as it's being used. Some types of patents: utility, design, or plants. I thought that was interesting. Utility meaning a device or process or product. Design, you can have visual design patent or non-functional feature. So like a design that's ornamental, you can reserve that. Or plant variety if you're really into horticulture. It must be novel and non-obvious. So not something that anybody next door could be like, oh, hey, what about this? You have to use patents in business, and it has to give you some sort of competitive advantage. Oh, sorry, I skipped over to the next thing, but that applies to patents too. So patents are expensive and lengthy, and if you ever are interested in working on them, you would probably be working with a specialist. An alternative to patents that I will get to next is a trade secret. So a trade secret is something that is confidential to you. Everything else that we've talked about so far is public information, publicly filed, governed by a state or federal agency. Trade secrets are the total opposite. They're confidential business information that you want to keep a lid on, keep it locked down, because that confidential information is what gives you a competitive advantage over the guy down the street. So easiest example of this is KFC's secret recipe over Popeyes. That's not something that they're going to file publicly. It's you might have an idea of what some of the spices are, but you don't know exactly what proportion they're in and exactly how it's made and how they cook the chicken and all of that. So trade secrets are protected by state law, which is an adoption of the Uniform Trade Secrets Act. Unlike the other federal laws for copyrights and trademarks and patents, they're very extensive and tell you exactly what you need to do in order to apply for these different registrations. The Trade Secrets Act is very short and it only gives primarily gives injunctive relief. It's just protection. It's not telling you how to manage your trade secret. So the protection would be if you have a client we'll just take Popeyes, for example. If Popeyes is your client and their employee goes and works for KFC and gives them the goods and tells them, hey, this is what they're doing down the street. You, as Popeyes, will want to get a handle on that pretty quickly. So under the Trade Secrets Act, you can take KFC and that employee to court and get an injunction requiring them to cease use of their trade secret and cease talking about it anymore, a gag order, so to speak. As I already mentioned, don't file them publicly, but you would want to identify trade secrets internally. Just, say that way you'll have at least some evidence in court that this is something that is valuable to the company. You want to protect trade secrets through confidentiality and non-disclosure agreements. That's the contracting piece that I'll get to in just a minute, and also careful office protocols. So contracts are not technically IP, but they are how we protect and trade IP. So contracts give permission to somebody else to use their IP under certain terms. So these can be standalone agreements like a non-disclosure agreement, or it can also be inside a larger contract. Like there might be a licensing clause, an assignment clause, or confidentiality sections. The terms that will need to be included are the cost. Any contract has offer acceptance consideration, so the cost is the consideration piece. Scope is, is it everything that I own, or is it just this logo that you can use? Is it just this song that you can cover, or this sample of the song? Duration, how long is this agreement in place for? Is it exclusive? Am I the only person that can sample this song, or are you reserving the right to let other people do that too? And any restrictions around it. So a lot of times in the business world, if we'll have something called a marketing services agreement. So they'll let somebody else, or if you ever see a collaboration on Instagram, the collaborator is allowed to use branding and logos and identification of the sponsoring company to make an offer of some sort. restrictions that would be in place there are the sponsoring company is probably going to want to double check and make sure that they approve of how their brand is being portrayed. An example of contracts. So an NDA, in case you're not familiar, non-disclosure agreement, that is something that would be signed between two parties that are looking to do business together, but they haven't actually gotten to the table yet and worked out all the details. So it allows people to be confident that the other party is not going to spill the beans and give away their proprietary information while they continue to work towards getting a deal done together. So an example, that's a standalone contract. An independent contractor agreement would have an example of IP clauses inside of it. So what this could do is you could have a whole section devoted to IP, just kind of some background on a contractor agreement. Say, I don't know, some of you might do contract work for multiple firms, but the contractor agreement is I'm hiring, Julie's on here, I'll use her as an example. Say I wanted to hire Julie for just a one-off job that I needed her to help me file a trademark application, but I don't need a continuing relationship with her. So I'm just going to pay her on a 1099 and keep her as a contractor. So the agreement goes through all the terms of why I'm hiring her, but as part of that, I want to make sure that my firm's intellectual property is protected and that she understands what is protected of hers as well. So typically in a contractor agreement, you're both going to keep things separate. I keep mine, she keeps hers. But anything that she works on for me is considered a work for hire, and my firm owns that, owns the ability to license that out, assign that if I want to. She cannot assign that without my written consent. Also it would include confidentiality language. So making sure that any confidential information that she's exposed to stays that way. And then at the end of it would also need to include whether or not these terms continue beyond the scope of the contract. So once she's done working for me on that project, you would want to make sure that the confidentiality requirements continue, so that just because she's done on that project, she can't go like posting on Facebook about all of my secrets. So I guess she could, but I would not be very happy about that. So you want to define when the contract itself terminates, but also when these particular clauses terminate. And as I mentioned, any independent contractor is most usually going to keep their own IP, but you want just to be real clear on how that works. So. Yay. That is the bulk of my content. So I can take some questions if there are any.
That's
So-
awesome, thank you.
Yeah, I think I have a question on the independent contractor agreement. So what if some IP comes about or something comes about after the contract's signed while they're working together? Can those be amended, or is it too late? Like, what
Sorry,
happens?
could you repeat that?
Yeah, so on the independent contractor agreement, you said that that they usually retain their own IP. So they've gotten this all worked out on who's going to retain what, but then what if something new comes about after their contract is signed?
Right. Okay. So that would be covered as well. So you would address those situations. But basically, the way I would structure it is so that as long as it's something outside of, as long as it's something that is unrelated to the work for hire, the thing that you were hired to do for the other company, then it's yours. But that's something that's very important to have a lawyer review and get it right. That would go for any employment contract too. So a lot of times you'll see overreaching by, I see this a lot in the tech industry, of they probably half the time don't even know that that's what they're asking their employees to do. But my husband is in tech, so I get to see his contracts, but they will a lot of times be phrased very broadly reaching to where it could be questionable whether anything that you're doing outside of your work for that company is owned by you or not. So you want to pay close attention to that. Most people are pretty reasonable if you review it and be like, hey, I'm not really comfortable with this. Let's rephrase and make it something reasonable. But it's our jobs as lawyers and paralegals to make sure that those are appropriately addressed.
One more question, and sorry if you covered it, but do people ever try to go do all of these things on their own without hiring a lawyer, and then it all goes to crap and they come back to you then later? Because we have that in many fields.
All the time.
And so how much, if you had to just give like a ballpark, how much does it cost to set up a trademark? Or, I mean, are we talking thousands, tens of thousands, or?
I would 1,000 to 2,000 for a trademark. It depends on how complicated it is. So I do flat fees for the search and for the application itself, but if there's an issue and we have to go back and forth with the trademark office, that would take quite a bit more time, and I would probably bill by the hour for that.
All right, that's it for me. Thank you.
And anything contract is going to be hourly. So, but that is a great question. So anything that I'm doing up front in a contract is going to be far, far less expensive than somebody who wings it themselves and then they get in trouble and we have to fix it either through negotiation or through litigation, which I would probably refer to Amber.
Okay, one more question, because my sister knows you very well, and she told me that you do entertainment law. Do you represent a lot of musicians in the IP, or other things?
No, so I primarily do business and real estate. So anything that dovetails on the business side of things. I recently helped somebody with a book deal and licensing the rights to that. There are Amy Mitchell Pooley, I believe, is a lawyer in town who does a lot of work with artists. But yeah, I do anything business related.
All right, thank you.
Well, I guess I'll wait and see if there's anything else, but thank you so much. I know that was a lot of info and a little time. So if anybody wants to reach out to me later, please do. I'll drop my email in the chat real quick.
Thank you so much, Emily. Does anybody else have any last minute questions? Okay, so this year, in lieu of the usual speaker gifts, CAPA has made a donation to Refugee Services of Texas in the name of the Morris Law Firm. Refugee Services of Texas is a social service agency dedicated to providing assistance to refugees and other displaced persons fleeing persecution based on race, religion, nationality, political opinion, or membership in a particular social group, as well as to the communities that welcome them. Thank you so much, Emily. We appreciate your presentation.
Thank you. And thank you for the donation. It means a lot right now.
Of course, sounds like a wonderful organization.
All right, thank you again, Emily. Before we wrap up and say goodbye to everybody, I just have a couple of quick announcements. We watch our social media and your email for some upcoming events. We're currently planning our Paralegal Day celebrations. Next month's speaker is Lisa Harding. speaking on criminal law. Watch, watch for information about whether that will be in person or via Zoom or both, whether that will be a hybrid. And we'll make that announcement soon and decision soon. In October, we have Lori Ratliff on appellate law, and in November, we have Neil Falgost from the city of Austin. Our spotlight committee this month is the Job Bank, and Amanda Garcia is our chairperson. Mike Rana is one of our volunteers with the Job Bank. Neither of them could be here today, but they asked me just to remind everybody that we have a Job Bank that is exclusively for CAPA members. It is very, very busy these days if anybody is looking for a job. The positions have been growing a lot over the last several months. Job Bank is looking at adding an out-of-state Job Bank page for anybody looking to leave Texas. And they're also looking at adding an option of an area on the website for members to post their availability, legal work experience, desired job position, sort of a job seekers page. So if there are any members that have suggestions, please reach out to Amanda and Mike at job_bank@kappaatx.org. And of course, if your firm hires anybody, or if you get a job through our Job Bank, let us know so we can advertise that. Next up, we have our door prizes. And I think, Jennifer, you have 2 gift cards, is that right? Okay. I am going to draw from my trusty hat here. And our first winner is Laura Kleiman. Congratulations, Laura.
Awesome.
And our second winner is Mary Lee Freeman. Mary Lee here?
She can't win, Ariane. She's a sustaining member.
Oh, sorry, I've got her listed here as a voting member. I'm sorry, Mary Lee. Okay. I think this person did not make the presentation today. How about Kelly Lumsden? Kelly here?
Yes, I'm here. Thank you.
Yay.
Yay.
Jennifer will email you their information, okay? If you don't,
That sounds good. And then I'll get them over to him quickly.
okay, sounds good.
Okay.
Next up is a Kappa gift card for Amazon in the amount of $25 for Angela Mengel. Is she here?
I see her.
Yeah.
I'm here. Thank you.
Okay, congratulations. And then last, we have a Kappa swag bag. And that goes to Ashley Vargas. I think Ashley's here, right? I think that's not her name. Ashley, are you here?
I see her too. She's here.
Yeah, okay.
Yes, I'm here. Thank you.
Congratulations. Thanks for everybody joining us today. And with all of that, our meeting is adjourned. Thank you, guys.